We are streaming, everything is ready.
Just a note that my screen share is disabled.
It should work now. Can you check, please?
Yeah, okay.
Dino, on to you.
Great, we can begin, can we, Lena?
I think so.
Great. Well, welcome everybody to the second day of these impressive deliberations that we are beaming live on YouTube and I think Facebook. I didn't hear anything about TikTok, so I'll hold my fire on that front. My name is Dino Kritsiotis. I am a professor of public international law at the University of Nottingham, where I co-direct the Center on Security and International Law. And I'll be chairing today's first panel. It's my great pleasure to be moderating the first of the two panels that we'll be having today, which follows what I'm sure you agree is a very helpful set of presentations and exchanges from yesterday. To recall, these concern the basic legal status of Crimea and Donbas, as well as the relation of humanitarian law and human rights in occupied spaces. Today, we shall be taking a few more steps in this area of study in international law. I'm very grateful to Global Rights Compliance for bringing us all together in this way, but I'm especially grateful too for the point of focus that they have given us for this morning's deliberations, which is obligations in relation to specific populations affected by the conflict. We cannot elide this factor of the trauma or indeed the inherent terror of warfare. How for civilians, violence it has to become the routine of the everyday. I'm put in mind of one of the poems of the Odessa-born poet, Yuliia Gorbunova, from his collection, Deaf Republic. It's a fantastic collection, which tells a story about the human impact of war. And the poem that I'm thinking of is entitled, quite simply, 4 a.m. Bombardment. And it speaks of him seeing the blue canary of my country pick breadcrumbs from each citizen's eyes, pick breadcrumbs from my neighbor's hair, how the blue canary of my country runs into walls, into streetlights, into loved ones. The blue canary of my country watches their legs as they run and fall. It's a very powerful way of demonstrating how warfare has this regularized impact. With these poems, we are put in mind or in the midst of a story that involves the killing of a deaf child by a soldier, and how in response, civilians feign deafness as an act of resistance. The human ear suddenly becomes a barricade to the acts of intimacy and violence. But what is it that the ear does not or will not hear? We really are very fortunate to have four superb speakers who will guide our thoughts and thinking on such matters, all of whom I am sure will keep professionally to the 10 minutes that have been allocated to them. But as I said to Amal at the head, we are humanitarians, so there will be some leeway. At the end of the 4 presentations, there will be a chance for you to pose your questions via me as chair, as we did yesterday. But please feel free to formulate these and send them to me in the meantime. This can be done by using the chat function, which you should be able to see on your Zoom panels right at the bottom. I shall now introduce each of our 4 speakers in turn before each of them takes the floor. First up is Neve Gordon, who earned his BA in philosophy from the Hebrew University of Jerusalem and his MA and PhD both in political science from the University of Notre Dame. Neve is Professor of International Law and Human Rights at Queen Mary University of London, and most recently is co-author with Nicola Perugini of Human Shields, A History of People in the Line of Fire with the University of California Press. This really is a most informative and insightful text, which join his many other important and enduring interventions in the field of international humanitarian law, amongst which I should call out Israel's occupation, which was published in 2008. Neve will address the topic of human shields and the location of agency. Neve, we're delighted to have you join us, and it's now over to you.
Thanks so much, Dino, and thanks to the organizers and other participants. I'm going to share a screen very quickly. So I guess you can see this. So human, just one second. So Human Shields is a book that Nicola and I wrote and came out a few months ago. And we're basically trying to tell the history of human shields through this book as a history that we use the human shield as the protagonist of the book, but the book itself is actually about how international law allows for humane violence. And the human shield is a very interesting figure to examine international law, we think, because it does not really sit well with the 2 axiomatic figures of international law, which on the one pole has the combatant, which is someone that according to the law you can kill. And on the other side of the pole, you have the civilian, which according to the law must be protected. And the combatant is imagined according to the law as a figure that is active and is participant in hostility through his or her activities, while the civilian is imagined according to the law as a passive figure who is an innocent bystander. And the human shield is actually an amalgamation of the 2, because on the one hand, it is the human, and in that sense, it is more like the civilian and calls upon us, maybe to cite Dino, to be humane and to act in a humane way towards this person. But on the other hand, the human shield is also a weapon of war. It is a shield. And in that sense, it fits more on the combatant side of international law. And so what we claim is that the human shield is a threshold figure that does not fit any of the 2 poles. And in many ways, international law does not have the vocabulary to deal with human shields. And it exposes a lot of the difficulties or some of the power relations within the law. But this is how the law defines human shields. The presence or movement of the civilian population or individual civilians shall not be used to render certain points or areas immune from military operations, in particular in attempts to shield military objectives from attacks or to shield, favor, or impede military operations. Now, much can be said about this definition, but I would like to just highlight two issues. One is the presence or movement of the civilian population or individual civilians should not be used to render. Used, as you will see, the agency here is not the civilian, but is someone else, and the civilian is passive. But what this also tells us, it shall not be used, meaning it is illegal to deploy human shields. So on the one hand, the law avows the illegality to deploy human shields. On the other hand, the law tells us that it will not make the area immune from attack. So it is illegal to use human shields, but also we can kill human shields. Okay, so the law relaxes some of the protections that it offers civilians in cases of human shielding. Now, there's basically three types of human shields: involuntary human shields, voluntary human shields, and proximate human shields. And the law does not really make these distinctions. And for the most part, it is discussing the involuntary shields. And what the distinction between these three different shields is based, we claim in the book, on the location of agency. Where is the agency in each case? Okay, so if we look at the case of Dar Farouk, Indian citizens from Kashmir who was tied to a jeep, like you see in the image here, and the jeep patrolled the towns for maybe 5 hours, and he was used by the soldiers to protect, or ostensibly used by the soldiers to protect the jeep from angry civilians throwing stones. So the agency here is not with Farouk, but actually with the soldiers that tied him to the jeep. The second kind of human shielding is a voluntary shielding. This is an image of Rachel Corrie in the Gaza Strip, and basically what the agency here is with the voluntary shield. And what we understand here and in the image before, that human shielding is actually a politics of vulnerability, because it is not the force or the power that the human shield has which helps it deter an attack, not deter, but the aim is to deter an attack. But it is actually the vulnerability of the human body that is used, and the moral claim that it kind of makes to the enemy: do not kill this vulnerable body. And it can deter or not deter. Now, what we see in many areas around the world is that the history of human shields in our book is also a history of the human body and a history of the hierarchy of the human body. And so the human body, not in its biological sense, but in its political sense, has a hierarchy. And it is not coincidental that Rachel Corrie, a white woman with a passport from the United States, has more and is privileged in relation to the people that she is trying to protect here in Rafah, in the Gaza Strip. And so she basically has more value in the eyes of the soldier than the people of the Gaza Strip. So she is using her value and her privilege as a white American in order to try to stop an attack. We all know that she did manage to stop a few attacks, but ultimately she was murdered by the driver of the bulldozer. But what is important here is that the fact that she can use her own body as a human shield tells us that she has some privilege. And to complicate that, she is on the one hand very courageous, using her privilege in order to stop an attack, but on the other hand, she is reinforcing that privilege at the same time, because she is asserting her privilege and reinforcing a certain hierarchy in the international arena. But what we see here, if I go back to the whole issue of agency, what we see here is that she has the agency, and when she stops serving as a human shield, then the Human Shielding Act stops, and she becomes a civilian again. I'm gonna jump this and go directly to the third kind of human shielding. In a study Nicola and I carried, what we found that over a period that we looked at the mention of human shields in newspapers, our major newspaper publications around the globe, we found that about 99% or 98% of human shields that are mentioned in the articles are neither voluntary shields or involuntary shields, but they are what we call proximate shields. Proximate shields are shields that are trapped in urban zones, because most of the fighting today in the world takes place in urban settings. So you have a city with several 100,000, sometimes millions of people in it, and there's fighting taking place in it. And by definition, once the fighting takes place in the city, there is proximity between the protected civilian actors and the combatants that are fighting. And this proximity, we claim, is being used to basically cast the whole civilian population as human shields. So what we have is the disappearance of the battlefield. And in the battlefield, the distinction between combatant and civilian, which is arguably the bedrock of international humanitarian law, disappears, because you cannot have that distinction, or it is very, very difficult to sustain that distinction in a city. And what we see is how the forces that tend to attack cities tend to frame the civilian population as human shield. Now, that framing is very important, because once the civilian population is framed as a human shield, it means that the militants that are hiding in the city carried out a war crime, because it is illegal to deploy civilians as human shield. And if let's say I'm attacking the city, if I attack the city and kill civilians while I attack, I cast them as human shield, and then the blame for their death is not on me, but on those that deployed them as human shields. And
Neve,
so
can I ask you to start bringing the presentation to an end?
Yes, so I'll just end with this. What we see here is basically the days before the attack on Mosul, and the United Nations comes out with a press release, ISIS, and you have at the time a few hundred fighters in ISIS in the whole city, holds 100,000 human shields in Mosul. Now, they do not need agency to hold 100,000. It is merely their proximity to the civilians. The whole civilian population is cast as human shields, and that allows and creates a situation where the civilian population becomes more killable. Now, I haven't finished, but I'm going to leave it at that because in the interest of allowing the other speakers to speak, but I'll be happy to answer questions in the Q&A. I'm going to stop sharing my screen now.
Great, Neve, thank you for that excellent start to our presentations. Also, with the very helpful images that create a separate point of focus for us, driving home the various categorizations and taxonomies that you were developing in that presentation. Our second speaker is Yuliia Gorbunova. Yuliia's bachelor's degree in law is from Tyumen State University in Russia, and she also holds a master's degree in professional communications from the University of Western Sydney. At the present time, she is Ukraine and Russia senior researcher in Human Rights Watch's Europe and Central Asia division. Her particular engagements have concerned the crisis in Ukraine, especially in the Crimea, with concern on enforced disappearances, the prosecution and detention of Crimean Tatar and pro-Ukrainian activists, as well as abuses undertaken by paramilitary groups. All of this by way of preface to her presentation for us today, which is entitled The Tatars and Prisoners. Yuliia, a warm welcome. Lovely to have you with us. You have the floor.
Thank you very much. Thank you for having me. It's a pleasure to be speaking on this panel. I've been asked, in fact, to speak about the situation of Crimean Tatars in occupied Crimea. And I would like to start by saying that Human Rights Watch researchers and myself have been on the ground in Crimea from the very beginning of the occupation. And we've published dozens of reports to make sure that voices of people who live through human rights abuses in Crimea are heard widely, heard by policymakers. And also we did that to try and amplify work of very courageous lawyers, human rights defenders and activists who living in Crimea in smaller and smaller numbers and continue to put their safety and their liberty on the line. I would also like to say that Human Rights Watch has a long-standing policy on laws of armed conflict, according to which it remains neutral on military occupation of another country. So Human Rights Watch does not take a position on military occupation of another country. However, like many other international organizations, we seek to ensure that international laws that govern conduct of war and occupation are respected. And once we have made a factual determination that the situation in Crimea was in fact an occupation under international humanitarian law, also like much of international community, we found that since Russia occupied Crimea and began transferring its and applying its legislation, including very repressive legislation in Crimea, it has severely curtailed human rights protections and violated its obligations under international law as an occupying power, in particular as concerns its obligations to protect civilians' rights. I'll go very briefly over those obligations and the laws of occupation. And as I speak, I will give examples of where exactly violations occurred, although there were too many to name them all, of course. Under laws of occupation, Russia has an obligation to restore and ensure public order and safety as an occupying power as far as possible, while respecting, unless absolutely prevented from doing so, Ukraine's laws prior to March 2014. Russia is also responsible for upholding order and for violations under international humanitarian law and human rights law, which were committed by local authorities or proxy forces, and has a duty as an occupying power to prevent and prosecute such violations. And lastly, it's important to remember that all international human rights law remains applicable in Crimea. And that includes all treaties that were ratified by Russia, such as European Convention on Human Rights, International Covenant on Civil and Political Rights. From the very beginning, Russia has thoroughly persecuted people critical of the occupation. It used a very wide arsenal of tools to do so. And they included, of course, disappearances, false prison charges, harassment, intimidation, unlawful expulsion, barring people from entry. And Russia particularly targeted Crimean Tatars as a peaceful and unified and very strong voice from the very beginning, which was consistently critical of Russia's actions in Crimea. I'll give you a few examples in a timeline which will show how that persecution grew and intensified from March 2014. In the spring of 2014, authorities failed to rein in paramilitary groups that were effectively running the peninsula at the time. They were implicated in grave human rights abuses, including torture of Crimean Tatar activists and basically all people and activists who were perceived as supportive of Ukraine and critical of Russia. Authorities barred Crimean Tatar elders, starting with Mustafa Dzhemilov, who is the leader of Majlis, Crimean Tatar representative body. Mustafa Dzhemilov was banned from entering Crimea in 2014, and that ban was recently extended to another 13 years. Russian authorities started very deeply coercive passportization process where they effectively forced Crimean residents to either accept Russian citizenship or declare an intent to keep a Ukrainian citizenship. However, this was done in a way which did not establish clear procedure for, first of all, for retaining Ukrainian citizenship. The timeline was very short to do so. And effectively, that led to people who retained Ukrainian citizenship becoming foreigners in their own homes, people with no rights, which is also a violation of laws of occupation. Russia very quickly started applying its vague and overly broad anti-extremism legislation in Crimea, and that process only have intensified since then. Authorities started by issuing a series of warnings, anti-extremism warnings to Crimean Tatar bodies such as Majlis. And then they conducted several waves of very intrusive searches, and I witnessed some of them. And I also interviewed families that went through that, and it was a terrifying experience where dozens of armed men in masks would show up at early morning at 5 a.m., wake up the kids, break into houses, looking for what they said they were looking for: drugs, prohibited literature, and weapons. Such searches were conducted also in Islamic schools, madrasa, and in mosques. Authorities also banned almost immediately all gatherings, including commemorative gatherings for Crimean Tatar community, harassed continuously Crimean Tatar media outlets, refusing to re-register them under Russian laws, issuing multiple anti-extremist warnings, and eventually and effectively pushing them out. And finally, authorities started dozens of criminal proceedings against Crimean Tatar activists on trumped-up charges of extremism and terrorism. And using terrorism charges against Crimean Tatar community actually proved to be an extremely convenient tool for Russian authorities to stifle dissent, because on one hand, there's already a very established practice of using these charges in Russia. And so the practice, the experience and legislation was already there. And basically what the authorities did is that they framed all activists, so members of Crimean Tatar community that they wanted to effectively silence, as affiliated with Hizb ut-Tahrir, which is a pan-Islamic movement that seeks to peacefully establish caliphate, but it does not espouse violence to achieve its goals. And that movement is and has been legal in Ukraine and most European countries, but is prohibited in Russia. Again, that's a violation of laws of occupation, because Russia does not have, as an occupying power, cannot impose legislation that contradicts laws that were in place before the occupation. These charges of affiliation with Hizb ut-Tahrir have been applied both to actual members of Hizb ut-Tahrir and perceived members of Hizb ut-Tahrir, and they're serious charges. They draw very long prison sentences, as long as 19 years. Some people are serving them, most people are serving them outside Crimea, which is also a violation of laws of occupation, because it's basically equivalent to deportation. In total, there are 80 people that have been arrested on these charges, and so far 34 have been sentenced to extremely long prison sentences. It's also important to note that none of the people sentenced have been accused of any violent acts, participating in violent acts, preparing violent acts, carrying out any acts of violence. And we also documented more searches, more waves of searches similar to the ones I described earlier, on charges of extremism and terrorism more recently, where we have documented cases of authorities using planting evidence and using torture to people to force them to confess. And finally, I would like to point out that very grave human rights abuses that took place in 2014, which I briefly mentioned in the beginning of my presentation, were enforced disappearances. And the majority of those cases in early months of the occupation were Crimean Tatar activists, including the case of Rishat Ametov, who was forcibly disappeared with the so-called self-defense units implicated, the paramilitary forces that were running the show at the time. There's video footage of them taking him away from a protest, a one-man protest, effectively a picket. He was later found dead. with his body bearing signs of torture. And there have been in total 43 cases of enforced disappearance documented by OHCHR mission in Ukraine. It includes 39 men and 4 women. And that comprises 11 people that are still missing. There haven't been effective investigations of any of these disappearances, even though majority have occurred in, as I mentioned, in 2014.
Yuliia, can I ask you to start wrapping up, please, your presentation?
Sure, yes. In fact, that's really the last point that I wanted to make, and I'm happy to answer any questions. Thank you.
Great. That was really excellent as well. A great exposition of the silencing and suppression that's been taking place in the framework of the occupation, which picks up on many of the themes of yesterday that we heard. So thank you very much for that, Yuliia. Our third speaker to join us is Elina Shyshkina, who holds a doctorate in public international law and was trained at the House of Commons of the Parliament of Canada and at the European Court of Human Rights. She was a member of the Parliament of Ukraine of the 6th convocation, which was 2007 to 2012, and has over 15 years of professional experience, including state functioning, political activity, program management, legal analysis, and advocacy work. She specializes in the protection of human rights, especially for conflict-affected persons. So this is a terrific panel for her to be joining. In July 2017, Dr. Shyshkina joined the charitable foundation Right to Protection as a legal analyst on housing, land, and property issues of conflict-affected persons, and very recently was promoted to the role of advocacy coordinator. The concern of her presentation will be internally displaced persons affected by hostilities, a much neglected topic, if I may say so. And I believe the presentation is going to be delivered in the Ukrainian language. However, there will be a simultaneous translation in both directions, that is from Ukrainian into English and English into Ukraine. But in order to avail yourself of the facility of translation, you will need to turn on your translation button in Zoom, which is at the bottom of your Zoom panels, and you will either click into the relevant language. I think we're all set. Elina, please can I invite you to deliver your presentation?
Thank you so much. Good morning, colleagues. First of all, I'd like to say some words in English that I am very grateful to you to invite me to make a speech, to make a presentation in this very valuable and useful international legal conference regarding occupation of Crimea and the armed conflict, armed aggression in Ukraine. Я буду говорити дійсно українською мовою і почну з того, що наша сьогоднішня панель присвячена темі зобов'язань держав і, власне, зобов'язанням держави Україна в тому, що стосується захисту людей, які постраждали від збройного конфлікту. І перш за все, я би хотіла сказати, що на міжнародному рівні, у тому, що стосується питань внутрішнього переміщення і прав внутрішньо переміщених осіб, тобто переселенців, наявними є акти міжнародних організацій і інституцій міжнародних організацій. Тут варто згадати керівні принципи ООН з питань внутрішнього переміщення, наприклад, доповідь про реституцію житла та майна в контексті повернення біженців і внутрішньо переміщених осіб, або так звані принципи Пінейру, а також резолюції і рекомендації інституцій Ради Європи, зокрема Комітету міністрів і Парламентської асамблеї. Зазначені документи є актами м'якого права, тобто вони мають рекомендаційний характер і часто є керуванням до дії, своєрідним дороговказом для держав які необхідно застосовувати у внутрішньому національному законодавстві з метою захисту прав постраждалих від конфлікту людей. Водночас треба зауважити, що їхні положення спрямовані на вирішення певних питань, регулювання яких відсутнє у міжнародних договорах. З іншого боку, положення цих актів м'якого права спрямовані на більш повне розкриття змісту загального зобов'язання держав за міжнародним гуманітарним правом і міжнародним правом з прав людини. Якщо говорити про таке зобов'язання, то воно в загальному сенсі говорить про те, що держава зобов'язана надати захист людям, які постраждали від збройного конфлікту, і мінімізувати ті негативні наслідки, які виникли у зв'язку з внутрішнім переміщенням і, власне, зі збройним конфліктом. Про це говорить, перш за все, принцип 3 керівних принципів ООН з питань внутрішнього переміщення. Загалом таке зобов'язання складається з низки інших обов'язків, які так само перелічені у керівних принципах з питань внутрішнього переміщення. Щоправда, в цьому документі ці обов'язки не зазначені прямо, вони викладені через права внутрішньо переміщених осіб. Наприклад, право на життя, право на повагу до їхньої гідності, право на особисту недоторканність, власність, право на освіту, медичну допомогу, повноцінну інтеграцію у приймаючі громади і так далі. Однак ми не повинні забувати, що кожному праву людини кореспондує відповідний обов'язок держави. Таким чином, навіть якщо певні обов'язки держави прямо не зазначені в керівних принципах ООН, тим не менше вони випливають, вони корелюють з тими правами, які перелічені в цьому документі. А отже, ми говоримо про комплекс міжнародних зобов'язань держав, які випливають з їхнього загального обов'язку захисту людей, які перебувають під їхньою юрисдикцією і які постраждали від збройного конфлікту. І тут неважливо, чи є держава жертвою збройної агресії, а це саме випадок України, чи йдеться про інший вид конфлікту. Йдеться про загальне зобов'язання держави захистити своїх громадян, тих, які зазнали внутрішнього переміщення і стали переселенцями. Тому, коли йдеться про створення національних законодавчих норм щодо захисту переселенців, то національний законодавець повинен спиратися, перш за все, на міжнародні договори, які містять, власне, міжнародні зобов'язання держав, але також і на акти м'якого права, які спрямовані на розвиток положень цих договорів. І, не дивлячись на їхній рекомендаційний характер, вони слугують дороговказом певного напрямку руху, тобто своєрідною дорожньою картою, що треба зробити, щоб захистити переселенців. Тепер повернемося до України. З того, що я сказала, можна сказати так, що як правозахисниця я зустрічала кілька підходів щодо того, що я щойно сказала про співвідношення актів м'якого права з національним законодавством. Перший підхід, і ним, як правило, послуговуються практики, тобто ті люди, які безпосередньо пов'язані з реалізацією зобов'язань, з виконанням зобов'язань держави, я маю на увазі України, перед своїми громадянами, перед людьми, які знаходяться під її захистом. Це те, що навіть акти м'якого права мають бути враховані при розробці національних законів. Інший підхід, він притаманний більше державі, державним чиновникам про те, що акти м'якого права мають рекомендаційний характер і вони лише можуть щось радити державі, державним органам, як діяти. Водночас, якщо ми подивимося на національне законодавство України, то все ж таки можна сказати, що в ньому враховані як і міжнародні зобов'язання за міжнародним гуманітарним правом, за міжнародним правом з прав людини, так і певні акти м'якого права. Однак до цього зараз повернемося, оскільки не все так просто з національним законодавством, як може здатися на перший погляд. Перш за все, хотілося би сказати, що у зв'язку, починаючи з 2014 року, коли Україна зазнала великої хвилі, тобто значного кількості внутрішньо переміщених осіб, великої хвилі внутрішнього переміщення, виникли проблеми які на сьогоднішній день ще залишаються невирішеними. Тобто вони, можливо, частково знайшли своє відображення в національному законодавстві і свої вирішення, однак це вирішення не є остаточним, звісно. Серед таких проблем варто вказати, наприклад, на забезпечення житлом внутрішньопереміщених осіб. У цьому йдеться про можливість переселенців брати участь у житлових програмах на придбання житла або про забезпечення їх тимчасовим житлом державою, або можливість брати, наприклад, низьковідсоткові кредити для придбання житла і так далі. Але забезпечення житлом є корінною проблемою для переселенців, оскільки воно безпосередньо пов'язане з їхньою інтеграцією у приймаючих громадах. Якщо є житло, якщо є робота, переселенцям значно легше адаптуватися і значно легше інтегруватися у приймаючі громади і налагодити своє щоденне життя. Тому вирішення питання з житлом є одним з необхідних проблем, яка потребує, власне, і комплексного підходу, і не лише зафіксування в законодавстві, як у комплексного підходу. Це і законодавчі норми, і державні програми, і належне фінансування, і багато інших речей. Ще однією проблемою є соціальний і пенсійний захист переселенців. Тут однією з проблем є наявність, своєрідна певна така залежність довідки переселенця, яка справді переселенців ставить у залежність, її необхідно постійно пред'являти для того, щоб отримати доступ до певних послуг, власне, для того, щоб отримати ту ж саму належну пенсіонерам-переселенцям пенсію. Також з довідкою ВПО пов'язані інші питання, такі як верифікація та персональна ідентифікація, доступ до медичних послуг і до, в принципі, багатьох послуг, які є наявними сьогодні в Україні, які надає держава. В багатьох випадках довідка ВПО є необхідним документом для пред'явлення, для того, щоб отримати доступ до певних послуг. Якщо брати, за приклад, ті ж самі житлові програми, то переселенці можуть в них брати участь за умови пред'явлення надання довідки переселенця. Тому тут теж є питання, чи, наприклад, в контексті пенсій, для того, щоб відв'язати довідку переселенця від права на пенсію, від доступу до пенсії. На сьогоднішній день, на жаль, ситуація інакша. Також однією з проблем, яка постала в зв'язку з переміщенням, є і виборчі права ВПО, тобто можливість для переселенців голосувати і бути обраними. Власне, ця проблема була вже остаточно певною мірою вирішена у 2020 році. Яким чином? З моменту переміщення переселенці отримували право голосувати і балотуватися на виборах, однак голосувати на виборах президента України і обирати частину парламенту України за національними списками, за партійними списками. Однак у тому, що стосується місцевих виборів, наприклад, обрання депутатів місцевих рад, мерів міст і так далі, до 2020 року переселенці такого права не мали. Лише минулого року були внесені зміни в закон, і їхнє активне і пасивне виборче право було повністю відновлене. Це один з прикладів дійсно такої успішної політики держави по відношенню до реалізації прав переселенців. І остання проблема, і вона є комплексна, і вона потребує довготривалих рішень, перш за все, це інтеграція переселенців у приймаючі громади. Як я вже сказала, це і питання житла, питання соціального захисту, доступу до освіти, до медицини, і виборче право і так далі. Тобто ми бачимо, що певні кроки вже здійснені, однак насправді ще багато роботи тут доводиться робити. Якщо говорити про рівень законодавства, то в Україні існує комплексний закон про забезпечення прав і свобод внутрішньопереміщених осіб, який встановлює гарантії дотримання прав, свобод і законних інтересів переселенців, проте не позбавлений недоліків. Наприклад, і ці недоліки виявлені протягом вже 6 років його застосування. Серед таких недоліків можна, по-перше, віднести доступ до послуг, створення рівних можливостей на рівні з мешканцями приймаючих громад у прийнятті участі у прийнятті рішень на місцевому рівні, наприклад, доступ до послуг, як я вже сказала, і так далі. Однак на сьогоднішній день формально, з формальної точки зору, переселенці залишаються невидимими для місцевої влади, і оскільки вони переважно з формальної точки зору не є мешканцями громади і не мають зареєстрованого місця проживання в громаді. Тобто це теж одна з проблем реєстрації місця проживання, яку необхідно вирішити. Їхнє проживання в громаді таким чином вважається непостійним і має наслідки для їхніх прав. Власне, для цього і були розроблені законопроекти, і я хочу сказати про законопроект 4487, який вже отримав позитивне попереднє рішення Комітету з прав людини Верховної Ради і очікує на своє схвалення у парламенті, можливо, найближчим часом. Це законопроект про вдосконалення закону про переселенців. Також я би хотіла, можливо, одним з останніх пунктів своєї промови вказати на загальні проблеми в законодавстві, які пов'язані з захистом прав переселенців. Окрім цих суто практичних питань, на які я вже наголосила, хотілося б більш загальні окреслити речі. Перш за все, це те, що в багатьох випадках немає чіткого законодавчого регулювання. Одним з таких прикладів були, власне, виборчі права, але, як ми бачимо, цей момент, принаймні в цьому контексті, вже проблема є вирішеною на рівні законодавства. Однак 6 років переселенці не могли голосувати на місцевих виборах. Слава Богу, зараз ця проблема вирішена. Інша така більш комплексна проблема є порушення принципу правової визначеності при формулюванні законодавчих норм. Тобто, коли створюється законодавство в контексті захисту прав переселенців, часто норми сформульовані так, що при їхньому застосуванні вони допускають різне читання і порушується принцип правової визначеності. Практика їх застосування є неоднорідною. І часто, певною мірою, виконавці закону, грубо кажучи, тлумачать закон так, як їм вигідно. І третя проблема, яку я маю окреслити, це неузгодженість і неструктурованість підзаконних нормативно-правових актів між собою, а часом навіть їхня пряма невідповідність закону. Тут можна говорити, на яскраво це виражено в контексті пенсій для переселенців. І якщо підводити вже підсумок і робити висновки моєї доповіді, то я би наголосила на 2 важливих речах. Перше, те, що зобов'язання держав, якщо ми переходимо до першої частини, зобов'язання держав, вони втілені не лише в міжнародних договорах, але також можуть бути розвинуті в актах м'якого права. Якщо ми говоримо про таку чутливу тематику, як захист прав переселенців, то національному законодавцеві варто не лише спиратися на міжнародні договори, але і враховувати норми м'якого права для того, щоб зробити цей захист максимально ефективним. І другий висновок – це те, що все ж таки національне законодавство України в контексті захисту прав переселенців потребує свого вдосконалення, знову ж таки з урахуванням міжнародних актів у цій сфері. Дякую за можливість дати таку доповідь, і я буду готова відповісти на питання, якщо такі будуть.
Elina, thank you very much for that wonderful, wonderful presentation. It was very full of points of law in terms of regulating treatment of IDPs and actually throwing up for all of us the nature, the range of challenges that are faced by states. So that's a fantastic presentation to have. If I may, can I also thank our translators who you've given a good challenge to. I very much appreciated having that in English. So thank you to the presenter and to the translators. Our final speaker for this panel is Amal Nassar, who is a consultant at the Global Survivors Fund, which aims to enhance access to reparations for survivors of conflict-related sexual violence, and a sexual and gender-based violence rostered expert at Justice Rapid Response, which is a network of criminal justice professionals who can be deployed to investigate, analyze, and report on international crimes and gross human rights violations. Amal has worked on the documentation of a series of international crimes, including those committed against children in Syria and Iraq, also very much a neglected topic in my view. But she has also worked on access to justice and the rights of victims and survivors in an array of jurisdictions throughout the world. Previously, Amal has worked for several civil society organizations, including the International Federation for Human Rights and the Coalition for the International Criminal Court, which closely follows other work that she has been doing. She has consulted with various international and national organizations, including UN Women, the International Independent and Impartial Mechanism for Syria, and Madre. Amal has published on sexual and gender-based crimes, which will inform her presentation today. Its title is Sexual and Gender-Based Violence and Gendered Aspects of the Conflict in Ukraine. Amal, a warm welcome. It's over to you.
Thank you very much for this warm welcome, Professor. And thank you very much for the GRC for organizing this very pertinent conversation and for inviting me to reflect on obligations in relation to sexual and gender-based crimes in the Ukrainian conflict. I'm just trying to set up my screen, so bear with me. Yes. Similar to the previous speaker, I will, in my presentation today, strive to highlight the obligation of the Ukrainian government in relation to persons who were victimized, including in acts of sexual and gender-based crimes. I will not so much focus on the obligation of the conflict's parties to take measure to prevent sexual violence, and instead, I will focus on an area that is subject to research and a study that I'm working on with the Global Survivors Fund, which is focused on the right of survivors of conflict-related sexual violence in Ukraine to a remedy, and specifically to reparations. Unfortunately, there's still a lot of misunderstanding around conflict-related sexual violence, including around its definition. Often it's understood as rape only, and only as an issue affecting women. So I just wanted to put a definition on this term. Conflict-related sexual violence are incidents or patterns of sexual violence that include rape, sexual slavery, forced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity that occur in conflict or post-conflict setting with a direct or indirect link to the conflict. These crimes can constitute war crimes, crimes against humanity, acts of torture, or genocide. And of course, they can be committed against men, women, girls, and boys, but also against gender non-conforming persons. In our research, that is focused on conflict-related sexual violence in Ukraine, which is what I would like to focus on in today's presentation. We really pay attention to the gendered nature of the commission of conflict-related sexual violence, particularly in conflict settings. Often, and not only in Ukraine, conflict-related sexual violence is almost always gendered and deeply rooted in gender-based discrimination and gender stereotypes. In addition to the commission of sexual and gender-based violence, sexual violence being gendered, the impact of it too is gendered. But I also want to say that there are other elements to consider, not only gender, when analyzing crimes and assessing the harm. And therefore, an intersectional approach should be applied to the analysis of conflict-related crimes, including sexual violence, that considers any grounds that have played a role in the targeting of persons and may have impacted the harm that they experience. For instance, in our work, we pay significant attention to other grounds that aggravate the situation of survivors and played a role in their targeting, whether that is their political affiliation, actual or perceived, but also their demographical background, which includes their language, their ethnicity, their religion, and their personal backgrounds as well, their education, their social status, their professions, and so on. And why do we do that? Why is gender and intersectional analysis of crimes, all conflict-related crimes, including sexual violence, so important? Because they help us in understanding the harm suffered by survivors and in understanding how they can access the right to a remedy, and what modalities do we have to consider in enabling survivors to access remedy and reparations. Coming to the Ukrainian context, I can perhaps argue that the topic of conflict-related sexual violence is also somehow neglected or does not receive attention in a similar way that other more visible crimes receives attention. For instance, perhaps detention can be more visible than conflict-related sexual violence. Additionally, we are also confronted with the absence of data. We don't know the exact scale and scope of conflict-related sexual violence in Ukraine. There are no numbers of cases or survivors, and this absence is confirmed in the current Ukrainian National Plan for the implementation of Security Council Resolution 1325 on women, peace, and security. But this is not an issue unique to Ukraine. In fact, in most conflict situations, it's really difficult to measure conflict-related sexual violence in a numerical figure. This is somehow related, of course, closely related to the underreporting of conflict-related sexual violence, which is due to different reasons, numerous reasons, including the trauma suffered by survivors' reluctance to speak due to fear of stigmatization or reprisals, but also due to the lack of pertinent services that would enable them to speak. Additionally, lack to access to the locations where this type of violation and crimes have happened, or where survivors reside, also does not aid in documenting this type of violations and crimes. This is, for instance, the situation of Ukraine, where access to territories controlled by so-called people's republics and to Crimea is somehow limited. And for instance, United Nations documentation bodies have faced challenges to accessing these territories and to reporting on conflict-related sexual violence specifically. But still, what we know is that conflict-related sexual violence has been part of the Ukrainian conflict, and the documentation by UN reports shows that conflict-related sexual violence has been committed on the territory controlled by the government, in the context of detention, at government checkpoints, as a result of military presence in residential areas, but also in territories controlled by the armed groups in Donbas, in the context of deprivation of liberty, at checkpoints, and also resulting from the armed group's presence in residential areas and other factors exacerbating the risk of sexual violence. As for Crimea, sexual violence there has been very difficult to document due to the lack of access, but there has been few cases documented, particularly focusing on sexual violence committed in the context of deprivation of liberty at the hands of Russia. In light of all this, we must consider the rights and needs of survivors of conflict-related sexual violence. So what happens after the crimes and violations have been committed? In international and regional human rights and humanitarian law, the rights of victims and survivors to a remedy and reparation is enshrined, and this right is now widely accepted by states. The right to a remedy has two components. The first is a procedural right to access and participate in obtaining justice. And the second is a substantive right to redress the harm suffered, so the consequences of the crime. Reparations should be provided by the state for acts or omissions that can be attributed to it, that violate its obligations under international human rights law and under international humanitarian law. It should also be provided by any other person or entity liable for violations of international humanitarian law. However, in the event that parties liable for the harm suffered are unable or unwilling to meet their obligations, states should endeavor to establish programs for reparations and assistance to victims. And this, for instance, is a situation we are confronted with, where it's perhaps unlikely that armed groups in the East or Russia and Crimea will establish reparation programs to provide redress for survivors of conflict-related sexual violence committed by their own forces or groups. And certainly survivors should not be waiting for that willingness and readiness to change. Instead, the Ukrainian government should strive to fill that gap by establishing reparation programs that are inclusive of everyone, regardless the perpetrator. Under international law and practice, reparation must be victim-centric, victim-based, gender-sensitive, adequate, effective, and comprehensive, and tailored to the particular needs of the victim and proportionate to the gravity of the harm. Reparations should also be transformative. And what that means is that if the survivor's status before the conflict was already of systematic disadvantage, what is often needed is that reparations should transform and rectify that disadvantage, which is often the case, by the way, of women and gender and sexually non-conforming persons with a status that is somehow disadvantaged already prior to the conflict. Additionally, global guidance for reparations outlines 5 primary forms for reparation, which seeks to address the harm suffered and restore the dignity of survivor, acknowledge wrongdoing, and implement long-term reforms. Forms of reparation include restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. Unfortunately, the reality is that survivors who often struggle with long-term trauma, insecurity, economic and social disempowerment face significant challenges to obtain justice and an effective remedy, including reparations, to which they have a right. Generally speaking, even when reparations exist, they too often fail to involve, reflect, and address specific experiences, needs, and priorities of women, and adequately respond to their gender-specific harms, and also fail to acknowledge survivors of sexual violence and genuinely respond to the harms they experienced and the ensuing needs. And it is against this backdrop that the Global Survivors Fund was established as an innovative, survivor-centric mechanism whose mission is to enhance access to reparations for survivors of conflict-related sexual violence across the globe. In our work in Ukraine, we have been looking into the status of the implementation of survivors' right to a remedy and reparations. And while the research is ongoing, what I can note is that we have found a prevailing impunity around conflict-related sexual violence in Ukraine, with very few cases, criminal proceeding initiated that look into sexual violence either committed by the government forces or by armed groups. We also found the absence of comprehensive reparation programs or specific reparation programs for conflict-related sexual violence. So what are we working towards? We are working with our partners in Ukraine to firstly acknowledge conflict-related sexual violence and its victims and survivors. At present, there is no acknowledgement of conflict-related sexual violence as a problem. Secondly, we're working to advocate for ensuring effective and prompt remedy for all survivors, as enshrined in human rights law, international and regional. The recent adoption of Bill number 2689 by the Parliament of Ukraine to implement international criminal and humanitarian law into the domestic criminal code is a positive and important step, which enables the prosecution of sexual violence, conflict-related, as a war crime and a crime against humanity. But it also needs to be accompanied by additional steps, including the training of law enforcement agencies to work on conflict-related sexual violence. This includes trainings on the Istanbul Protocol and the Protocol on the documentation and investigation of conflict-related sexual violence. And also, it includes specialized trainings for the judiciary as well on the nature of sexual violence and the evidentiary standards. Another issue to consider is also the gender diversification of the police and law enforcement, especially their agents working with conflict-related sexual violence and other sensitive survivors, which would significantly help in the investigation and prosecution of sexual violence. And importantly, we're working towards advocacy for setting up reparations programs by the Ukrainian government. A discussion should be initiated as soon as possible to design reparation programs for victims of conflict-related sexual violence. This should happen soon before the harm becomes irreparable. End of a conflict, a peace agreement, or the establishment of a truth commission are not preconditions for the establishment of reparations. Prosecution of the crimes are also not essential for reparations. In fact, for conflict-related crimes, including sexual violence, which occur on a large scale, administrative programs for reparations have the potential of being more inclusive and accessible than courts, and of being more capable of reaching a larger number of victims, and of being more victim-friendly as their procedures are more flexible and their evidentiary standards and costs are significantly lower. But this is not to suggest that this should preclude victims from obtaining reparations through courts, as both options should be made available and should complement one another. Ukraine should also hold consultations with affected communities, civil society, and experts before deciding on the format and reach the possible best solution for the Ukrainian context. Survivors of conflict-related sexual violence in particular should be in the driver's seat of these conversations, as they are best placed to identify their needs and which forms of reparations they would like to have in place. And finally, years now into the conflict, we encourage the Ukrainian government to consider establishing interim reparation programs that would address the immediate needs of survivors while working towards full reparation programs to be established, which could in some cases take longer periods. So in the interim, there should be interim reparation programs as well. I think I'm pretty much out of time, so I will stop here, and I'm happy to elaborate on any of the points in the discussion. Thank you very much.
Amal, thank you very much for that very comprehensive presentation that highlighted the difficulties and challenges, but also gave some points of light at the end, which really encapsulates the main thematic of the presentation, which was really the harm and the rights of survivors that you brought to our attention. Right, well, that concludes 4 excellent presentations. And we now have, by my reckoning, 15 minutes to get to the coffee break. One of the most important provisions in the conventions, Geneva Conventions, is humanitarian assistance. And we'll all be needing some of that in 15 minutes' time. So those of you who want to raise questions, I'm actually going to allow the hand to be raised in the bottom hand of your panels. Press raise hand, and I will call upon those of you who raise the hand. But I do want to start with a couple of questions that have been directed to Neve Gordon for his presentation. Neve, this is from Irina Marchuk. Does the use of voluntary human shields make it less of a war crime? The Ukrainian government submitted the communication to the International Criminal Court on the use of voluntary human shields in Crimea during the takeover of Ukrainian military bases. However, it does not seem that the Office of the Prosecutor accepted this conduct falls under war crimes. So the issue of voluntary human shields versus the idea of war crimes. And secondly, there is a question that's just been posted by Elina Bocheva. Thank you for your presentation, Professor Gordon. The issue of proximate shields, which is the third element in your taxonomy, appears to be very acute in the context of the situation in eastern Ukraine. It comes together with a whole bundle of issues. Apart from targeting, there appears to also be a question of whether parties to a conflict were obliged to evacuate civilians, protect civilian property, etc., etc. This bundle of issues looks like quite a challenge in terms of the investigation and accountability. Could you speak more about particular situations or examples where attempts were made to entangle this sort of knots and to attribute liabilities? Neve, do you want to get us started by responding to those?
To be frank, I need some clarification. So maybe the first, who was it that asked?
This was Irina.
Irina, can you get online and just tell me which side was using voluntary shields? It wasn't clear from your question what was going on now. Hi.
Yeah, hi. Yeah. Thank you for this very nice presentation. Yeah, so these were Russians and Russian soldiers who were using Crimean population as voluntary human shields. And this precluded Ukrainian military forces to open fire. This also created the situation where, Ukrainian military bases were just taken over by the Russians. And so a number of non-governmental organizations, together with the General Prosecutor's Office, put together a communication to the ICC arguing that voluntary use of human shields by the occupying power constitutes a war crime. However, as I explained in my question, it doesn't seem that the Office of the Prosecutor accepted that legal qualification. At least it was not reflected in the annual reports that are published by the Office of the Prosecutor. And that's why, like, the question is, okay, so if we use voluntary human shields, does it make it less of a war crime?
So basically, you see, there's a kind of oxymoron in the way the question is phrased, because you're saying they used voluntary shields, the military used, and usually when we talk about voluntary human shields, it's people that are not used by the military, but that volunteer to do it. And 99% of the cases that we have looked at voluntary human shield, it's anti-violence people. It's people that try to stop the violence of both sides, or at least of one side. So it seems to me, but you'd have to correct me because I don't know that case, is that what the Russian military asked Crimeans to volunteer and stand between the forces so the Ukrainian army couldn't fire back at the Russians? Is that what happened?
Yeah. So the Russian military, which were disguised as the little green man, they could take over Ukrainian military bases.
Right.
So in other words, this was staged in order for the Russian military to take over the major military infrastructure of Crimea.
So I would, to be frank, I would need to learn the situation, but what I can answer is this, that actually, in terms of the law, voluntary human shields do not appear in the law. And the reason voluntary human shields do not appear in the law is that civilians are imagined as passive. And if they volunteer, they basically cross the line to participants. And once they cross the line to participants, they can be framed, even though they do not use violence, and even though it's just their body, they can be framed as participants in hostilities, and therefore they become killable. But the situation you describe seems to me extremely complicated, and I'd be happy to look at it. If you can send me something via email, I'd be interested to look at it and see what I can.
Great. There was a report which was published as well, which is public, so I'll be able to share the report with you. It's very unusual situation as well, which we see in Ukraine. And Wayne, who organized this conference, he also participated in the drafting of the ICC communication. And I think the mainstream position that we had, it doesn't matter if civilians participate voluntarily or involuntarily. What matters is the intent of perpetrator, and this is what makes conduct a war crime. So if the intent of Russian military was to render the area immune, that would make it a war crime. But we shouldn't be concerned as to whether civilians participated as human shields voluntarily or involuntarily.
Right.
Great.
I'll just say the only thing is that it's very complicated to demonstrate intent, to prove intent, and that's where it becomes problematic, right?
Irina, thank you for bringing that to our attention. Thank you, Neve. Neve, do you want to have a quick response to the notion of proximate shields appearing in eastern Ukraine and the question that was asked by Elina?
So again, I didn't understand exactly. If she could just clarify the question, then yes, I'd be happy to.
Hi, I suspect that even the Mosul example could actually address my question. I'm interested in the aspect of liability and investigation in the context of use of proximate shields.
Okay, so first, I didn't finish my talk, but I just wanted to kind of provoke. But what we found about proximate shields is that proximate shielding is not proximity to the fighting per se, but proximity to irregulars, to non-state militaries. So just as an example, when Israel fires at Gaza, then the Palestinian civilians in Gaza are cast as human shields if they are killed. When Hamas fires at Tel Aviv, and even though Israel's central command center is in the middle of Tel Aviv, also next to civilians, like in the Gaza Strip, if Hamas kills civilians, they are framed as civilians. So only civilians that are next to non-state militaries are cast as human shields. That's we found, and we're talking about millions of people when we look at articles in that way. And in terms of liability, it is about, again, the law does not precede its interpretation and does not precede the interpretation in the conflict zone. So it's all about how the violence has been framed, right? So if the actors managed to convince the international arena that these people were used as human shields, let's say by Hamas or by ISIS in Mosul or by the Russians or Ukrainians, whatever it will be, then the liable party is the side that used them, even if they were not really used, but several apartment buildings away from where the militants were shooting. So what we claim is that it's a lot about the semiotic warfare and not about only the warfare on the ground. It's about who frames and how the situation is framed that determines the liability.
Great, thank you very much, Neve. So I'm going to push us into the coffee break. I've been allowed to do that by the organizers. So the second question now is for Elina from Dr. Antal Burks. Dr. Shyshkina, many thanks for your thought-provoking presentation. I have a question regarding persons living in the territories outside of governmental control. The UN Committee on Economic, Social and Cultural Rights recommended to Ukraine to adopt legislation abolishing the requirement for residents of the non-government controlled areas to register as IDPs in order to access their pensions and other social benefits. How burdensome, Dr. Burks asks, is it to register as an IDP for persons who are living in Donbas, Luhansk? E.g., must residents prove and maintain residency in government-controlled areas and cross into the government-controlled territory every 60 days? Are those national legal requirements conforming to international law, in your view?
Дякую за запитання. Я все ж таки буду відповідати українською мовою, розуміючи, що питання було задане англійською, але в нас є перекладачі. Отже, питання пенсій. Почну з останнього. Чи відповідають певні законодавчі вимоги про верифікацію протягом 60 днів для осіб? Чи відповідають вони, власне, міжнародним зобов'язанням і міжнародному праву? Це питання, насправді, піднімається давно правозахисниками, і перш за все хотілося би сказати, що такі обмеження, вони передбачені, власне, підзаконними нормативно-правовими актами. Оскільки, якщо ми беремо рівень законів, законодавства України, то воно не вирізняє переселенців і громадян України, і інших людей, які проживають, наприклад, там, які не є переселенцями, проживають у Києві, Львові чи Харкові, але не є переселенцями. Те питання, яке ви підняли, стосується здебільшого тих осіб, які зареєстровані як внутрішньо переміщені особи, але фактично проживають на окупованій території. і вимушені справді часто перетинати лінію розмежування через КПВВ для того, щоб мати доступ до своїх пенсій. Тобто для них створюються ось ці додаткові обмеження і додаткові перепони, яких немає для людей, які не є переселенцями і проживають на підконтрольній уряду України території. Отже, якщо ми подивимося глибше, то справді такі перепони, втілені через підзаконну нормативно-правову базу, вони не відповідають, власне, Конституції України, оскільки Конституція говорить про право кожного на пенсію, на пенсійний захист, і говорить про недискримінацію, тобто немає дискримінації за ознакою, де людина проживає і ким вона є. Тобто, відповідно, як переселенці, так і люди, які проживають, які є громадянами України, але проживають виключно через певні обставини на окупованій території, так і люди, які проживають на контрольованій урядом України території, всі мають рівне право на отримання пенсії. Тому, звісно, що такі перепони, які створені, вони не відповідають, м'яко кажучи, Конституції України, перш за все. І, відповідно, також не відповідають міжнародним зобов'язанням України створити соціальний захист для переселенців, тобто забезпечити їм належно їм соціальний захист і доступ до пенсії. Якщо ви могли б ще раз повторити перше питання, то я була б вам дуже вдячна.
Could I repeat the first question?
Yes.
Yes. The UN Committee on Economic Social Rights recommended the Ukraine to adopt legislation. And the question was, how burdensome is it to register the IDP?
Власне, законодавство в нас розвивається активно. В контексті пенсії, якщо ми говоримо про, знову ж таки, пенсійну тематику, це питання є надзвичайно складним і, перш за все, складним для адвокації. І воно стосується і законодавства, і підзаконної бази. Не дивлячись навіть на те, що судові рішення, якщо ми говоримо про судову практику, яка складається для переселенців, то багато судових рішень позитивні для переселенців, тобто вони прийняті на користь позивача. Однак про виплату пенсії, про перерахунок пенсії, про виплату заборгованості і так далі. Однак тут питання, як я вже сказала, фактично в підзаконних нормативно-правових актах, які треба привести у відповідність до закону і до Конституції України, а таким чином виконувати свої міжнародні зобов'язання, тобто ми йдемо від самого низу. Якщо у нас є рекомендація Комітету ООН адаптувати, змінити законодавство, то для того, щоб захистити людей і виконати своє зобов'язання щодо захисту перед ними, то український уряд повинен на це зважати, як на мене. Але треба подивитися, де заритий собака, як у нас кажуть. Чи це питання закону, чи це питання підзаконної бази, і що про це говорить судова практика? Судова практика...
Sorry, can I ask you to wrap up because we've got many other questions I need to
власне, все. Судова практика в багатьох випадках стає на користь людей. І тому ці рішення також на них повинні зважати урядовці і парламентарі, коли вони будуть розробляти відповідне законодавство. На сьогоднішній день є вже законопроект 2083-д, лежить в парламенті, очікує на своє позитивне схвалення, якщо воно відбудеться, який, власне, і запроваджує механізм для отримання пенсії, доступу до пенсії, але і при цьому усуває ось ці restrictions, ось ці недоліки, які є в підзаконній базі.
Thank you so much for that, Elina. We will take a couple more questions I have here. One is to Amal. What would you recommend to survivors of sexual violence? And do you have examples other than Kosovo and Bosnia where the victim of sexual violence receive reparations? Amal, if I can append a question of my own. You mentioned a lot in your presentation about the problems of documentation. But we are now living in a technological age. I mean, one of the reasons why Black Lives Matter has come to the fore is because we have video evidence of police atrocities. So in the context of armed hostilities, is there any chance that we can possibly rely on that? And then there is a question I will invite from a member of the audience. So if you can answer those 2 points.
Great, thank you very much, and thanks for the question from Tatiana, who also wrote in the chat that she is a member of the SEMA network, which is a network of survivors in Ukraine, survivors of conflict-related sexual violence. So I really appreciate this question coming from a survivor and that perspective and urgency in raising it. In fact, what I want to reiterate is that survivors' efforts and lobbying and advocacy around the world in many conflicts have been a driving force for access to justice and for the establishment of reparation programs. We have seen that almost without that, it's very difficult to realize these rights, basically. So I monitor and I interact a lot with the SEMA network, and we partner up with them a lot. And I just want to applaud their power and their organization of themselves as a survivors group. And I want to say to Tatiana, what survivors can do is keep doing what you are doing, and it is our obligation as an international community to support you, and as a national authorities as well, to support you, to amplify your voices, and to make sure that your demands are heard. So I hope actually someone from the Ukrainian authorities is also listening to this conversation and hearing the urgency of the demands for reparation programs that Tatiana from the SEMA network has voiced. And examples other than those in the Balkan region and Kosovo, I want to say that, yes, as I said in my opening, in my presentation, unfortunately, there is no perfect example of a reparation program for conflict-related sexual violence, but there has been examples and programs that look at sexual violence specifically. I want to mention a recent example adopted in Iraq by the Iraqi parliament that establishes, firstly recognizes sexual violence against the Yazidis as a constituting act of genocide, and also sets the institutional framework for financial support and other forms of redress for survivors. There are also other good examples that one can look into and learn from, because they're not necessarily perfect examples, but also in Latin America. There's an example also in Libya where a decree was passed, because of course it can also be that reparation programs are established through a decree as well, but this example of a decree passed in Libya establishing a fund for reparations for sexual violence has not yet been implemented. So even sometimes when you have the decree or the legal and policy framework, if it was not followed by political will and commitment and resource mobilization, it does not materialize in concrete reparations being delivered to survivors. And finally, in relation to your question on the use of digital documentation, I think what is important in conflict-related sexual violence is that what we need to prove is not just the underlying crime. What we need to also prove is the nexus of these crimes to the conflict, or the fact that these crimes were committed in a widespread and systematic manner, so the existence of policies, orders, and so on, but also linkage to the perpetrators. And their digital evidence can be very useful. It can be used, for instance, to document certain locations, to document certain orders if they were recorded. It is now the trend that armed groups like to show off their crimes and not really hide them. So a lot of the crimes are documented in videos, recording, radio channels, and so on. So it certainly can help in the documentation of this type of crimes and violations. And I think I can add that it has also, I know that some groups working in Ukraine on the documentation of conflict-related crimes have also relied on digital evidence.
Wonderful, thank you. And of course, we have to bear that in mind when we think about the ubiquity of the mobile phone as a potential form of testimony for these acts of violence. Tatiana, did you have a further question to ask? Because I see that you had your hand up, and I wasn't sure if that question has already been asked to Amal or if it's a different question. So Tatiana, do you have another question? I don't know if that's been translated. Tatiana, do you have another question? I don't think she can hear us, or it's not being translated. Very well. Well, I think in the interests of giving us all a brief chance of, I think Tatiana's waving her hand, so I think that's a no. So I think I'm going to wrap up the panel and ask everyone to be back at 9:50 with facilitation from the organizers for that. Dr. Ian Scobie, thank you very much for agreeing to have latitude on the later start. So we'll be back at 50 minutes past the hour. But before we disappear, please join me in the inaudible applause to our 4 excellent presenters for getting the day going in such a profound and meaningful way. Thank you to all 4 of you. And of course, thank you to our interpreters once again. Thank you. Please be back at 50 minutes past the hour.
Hi, Ian.
Hiya.
So you're working, good.
Guys, warning you, we can all hear you. It's Manu.
Hi, Manu.
Hi, Manu.
Thank you for the warning. Going back offline.
Hey, Ian.
Hi, Charles. How are you?
Great to see you.
It's good to see you. How are you keeping?
Surviving is my usual answer.
You're looking well.
I'm okay. I'm doing okay. I'm pretty busy.
Right.
Pretty busy. not very mobile. Haven't been able to travel for ages, and had to adapt our work to that reality. Yeah.
I think we're all in that boat, Charles.
But I soldier on, and I'm sure you're soldiering on. How have you
My
been?
best.
How have you been?
I've been okay. I've been stuck more or less inside since March last year.
What? Inside?
Yeah.
Why?
Underlying health problem,
Oh,
which makes me susceptible to this virus.
oh geez.
I'm getting out now of it, but I've not been anywhere since March last year.
Yeah, well, I haven't, and I barely get, I get out of the house to go shopping. I got my shots, so I see friends more easily and less remotely.
Yeah.
And get to the office occasionally. One of my colleagues has been battling a prolonged health problem that kept us